Hi, thanks so much for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Kyle Cassidy, a New Jersey construction lien law guru. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Kyle Cassidy.
Thank you, Jesse, for the wonderful introduction. Good morning, everyone. Thank you for spending time with me, and I'm hopeful that this will be informative and hopefully resolve some issues or answer some questions you've had pertaining to New Jersey lien law. First things first, with respect to the way we'll operate the webinar, if you have any questions, please insert them in the chat box on the right, and I will answer questions at the end. And please do not include your name or any company names with respect to the questions. All right, for the agenda, we're going to work our way kind of from the contract, which would more be like the order of the temporal order of things. So you're getting paid faster through your contract, what you need to do to secure your lien rights. There's also bond rights. We'll talk a little bit about that. And then the traps that you need to avoid with respect to both lien and bond rights. There's a statute in the New Jersey, the Prompt Payment Act. We'll talk about that and the effectiveness that utilizing that statute has for the ability to get paid. And then once you get paid, the right way to actually execute a release or receive a check, and in order to preserve any other rights you may have. And then we'll discuss SunRay's resources. Getting paid faster through your contract. So things that are really important to consider. Well, this may seem obvious, but one thing that you need to do is you're going to want to have a written contract. Why that's important is sometimes, especially in the contracting world, there's a lot of old school contractors that prefer to do things, the old school way or by word of mouth. Well, if a dispute arises and and that does happen a lot in construction, well, the actual terms of that agreement are not anywhere memorialized. So you're going to want to memorialize the terms, particularly what the payment obligations are, what the timing of payment is. Getting to the next point, establish agreeable payment terms. So you're going to want to have a price, and that price sometimes could be based upon time and materials. Sometimes it could be based on a lump sum number. Sometimes there's unit costs. Well, all of those things need to be spelled out, and they need to be in writing. So there's a multitude of different contracting forms. You can write your own contract. You could use the AIA. There's a number of different forms, but you're going to want to have those specific payment terms and conditions laid out. Provide recovery and interest in attorney's fees and costs. So you may want to have in your contract language that gives you recourse if you do have to sue or if you have to file a lien in order to get paid. Well, you're going to incur costs to get paid. So you may want language in your contract that says, well, if I have to do that, then you are obligated to pay my costs, my interest, my attorney's fees. That's going to do a number of things. One, it'll provide for those costs to be reimbursed to you when you actually do collect, but it might also be a leveraging point that prevents someone from not paying you, because they're going to recognize that those additional costs, fees, interest will only increase their costs to ultimately owe you. Avoid pay if paid clauses. So going back to talking about agreeable payment terms. Well, if you are a subcontractor and negotiating with a contractor, and the subcontract says that you must receive payment, you only receive payment on condition of the contractor's receipt of payment from the owner. Well, that clause, there's two things to it. One, you will not get paid unless and until the contractor gets paid by the owner. So if some sort of dispute arises between the owner and the contractor, well, the contractor can use that dispute as a basis to not pay you, the subcontractor. And ultimately avoid payment entirely because New Jersey enforces those clauses. Now that language would need to have, there's what they call condition precedent language, saying that payment to the subcontractor is conditioned upon receipt of payment between the owner and the GC. So you're going to want to avoid that. What you would do instead is maybe say payment is due within 30 days of receipt of submission of a requisition to the contractor. You're going to use more timing language as opposed to conditional, making receipt of payment from the owner to the GC conditioned on payment from the GC to the sub. So that's something that's very important to look out for, particularly in New Jersey, because that language is enforceable. I have the last point here, ADR provisions. So ADR is alternative dispute resolution. That is a way in which the parties can resolve their disputes. One of which is mediation, which is a form of non-binding dispute resolution where both parties will meet with a neutral mediator who will assess the merits of each party's claim and try to negotiate a resolution. That can sometimes be beneficial in that those provisions can provide an opportunity to resolve a dispute before going to litigation, before going to court or arbitration and incurring those additional costs. These, in the same vein though, these provisions could also be unnecessarily burdensome because it could require an additional step that the contractor will have to go to in order to file a lawsuit or to ultimately execute its rights. So depending on the relationship between the contractor and the other party to the contract, you may or may not want to have a mediation clause, or you may not want to have a clause that requires binding arbitration, which is a form of alternative dispute resolution that's binding but not in court. So you can hire what's called an arbitrator to decide the decision, and those types of forums require that their fees be paid. If you file a lawsuit in court, you pay the filing fees, but you're not paying the judge for his time or her time. Whereas if you have an arbitration clause, you're going to pay that arbitrator for his or her time, and you also may have to pay the company that provides the arbitrator their administrative fees. So arbitration clauses can be very costly and may be something you don't want to have because it will increase the costs of actually litigating the dispute. Securing your lien rights. So you have a contract, presumably, and now you have a dispute where the contractor or subcontractor has not been paid and they want to file a lien. Well, in New Jersey, the construction lien is a form of lien that can be filed on a private project, meaning it's not a project owned by a municipality, a county, or the state of New Jersey. So you're building a office building for XYZ company, and you have a claim that you haven't been paid. Well, you're going to want to file the lien. The lien needs to contain, the contents I have delineated here: the name, the address of the claimants, the address of the property, the lot and block information. That's how the properties are identified on the tax map, the lot and block. The property owner, the general contractor, if there is one. So if you're a sub and you're filing a lien, you not only need to identify the owner and the property, but you also need to identify your contractor who you have the contract with. Is this a lien on the property itself, or is there a leasehold? For example, if you're doing work for somebody and that person who you're doing work for is not the owner of the property but is the tenant on the property, then you would only have a lien against the leasehold interest, which is valid in New Jersey, but obviously it's different than an ownership interest. The contract information. So if you're a sub and you're filing a lien, then you're going to want to put the date of the subcontract and what type of work was performed under that subcontract. You're going to need accounting of the amount that's due, and the accounting would include what the base contract amount is, approved change orders, if there's any credits, an amount paid to date, and then ultimately the amount that's due. And then very important is the last date of work performed or material supplied to the project. This is really important because it ties into the next part of the next point heading here, which is the deadline. If you identify a last date of work that's beyond 90 days, if it's a non-residential project, then you don't have a lien right, because you need to file the lien within 90 days of the last date of work performed on the project. Otherwise, your lien rights have expired. So that last date of work needs to be prominently a part of the lien, and it needs to fall within that 90 days. If it's a residential project, meaning it's an owner-occupied property, then there needs to be a lien, or what's called a notice of unpaid balance, filed within 60 days of the last date of work. So it's an even tighter deadline. So beware of those deadlines. They're extremely important. With respect to who can file the lien, only first, second, and third tier claimants may file. And no supplier to a supplier can file. And when I say first, second, or third, that would mean any contractor, subcontractor, or subcontractor to a subcontractor can file. Or a supplier to a subcontractor can, but no supplier to supplier. And then the lien will be filed with the county clerk where the property is located. Additional requirements. So after serving the lien is then, once you have a copy of it, needs to be served on the owner and the contractor, to the extent that there is one, within 10 days of the lodging, and that needs to be done by certified and regular mail. Once the lien is filed, it's important to calendar the deadline to file a lawsuit to enforce the lien. Now, I've seen this mistake before. Liens need to be filed within 1 year from the last date of work, not 1 year from the date the lien is filed. So if you file it from 1 year from the last date or the date that the lien was filed, you'll be untimely, the lien will be gone, and you will be left to your breach of contract action without any security under the lien. If it's a residential property that you filed the lien against, and which I referenced before, the 60-day notice of unpaid balance requirement, there's a different process that you go through after filing that notice of unpaid balance. Under the AAA, which is the American Arbitration Association, there's an arbitration process that confirms the validity of the lien. Once the lien is considered valid, then it may be filed. It's just a mechanism to protect people from filing frivolous or fraudulent liens against people's properties where they reside. The municipal mechanics lien is another statute in New Jersey that allows you to file a lien against municipal or county level properties. The lien does not serve to allow you to foreclose on the property itself. It allows for you to ultimately stop the payment of funds that are available for that project and seek to get paid those funds that are being withheld. Very similar lien content obligations, except for in this circumstance, the owner of the property is the municipality, so you have to file the lien with the either the board secretary or the president of that particular municipal entity. The deadlines are a little different. The deadlines are actually more lenient. It needs to be filed any time before the whole work has either been completed or accepted by resolution, or within 60 days thereafter. So you don't need to file it within 60 or 90 days of your last date of work. You need to file it before the project is accepted, and you still have a 60-day window thereafter to file. Similar obligations regarding the claimants who can file, and then the liens recorded with the municipal entity. Securing your bond rights. So a bond is different than a lien. A bond is issued by a surety company, and it's a form of a guarantee that provides payment to downstream subcontractors and suppliers. So for example, a general contractor is not paying its subs, then those subs can seek to get paid by the surety company. In order to secure that right, though, the claimant needs to file a statement of claim with the surety, which is just a basic written notice to the surety identifying the work that the contractor performed, the amount that's due. They'll likely need to provide backup information, invoicing, any other emails or correspondence that confirm payments owed, the bond number, just the general specifics of the project, who was the work was being performed for, but the surety needs to be given that information. Once they receive that information, there's an investigation process that the surety will go through and ultimately determine whether the claim is valid. If the surety during the investigation process, though, doesn't issue payment, it's incumbent upon the claimant to preserve its rights under the bond by filing a lawsuit. The lawsuit needs to be filed within 1 year from the last date of actual work or materials delivered to the project. And it cannot be filed within the 90-day window between the notice of claim and so once you provide that notice of claim, you have to wait 90 days to file the lawsuit. So that's why you really can't wait to file the notice of claim. If you're owed money on a public project in New Jersey, and because bonds are mandatory on public projects, if you're a subcontractor or a supplier on a public project in New Jersey, find out, and you're owed money, find out what the bond information is, who the surety is, and send your statement of claim in as soon as possible. And then immediately calendar your deadline to file a lawsuit based upon the 1 year deadline from the last date of actual work or materials delivered to the project. Similar to the lien law, the same parties who have rights to file liens also have rights to file bond claims. Now, while it's not mandatory, some private projects also are bonded. So if you're a subcontractor on a project that's not a public project, it's worth to find out whether or not there's a bond there, because if there's a payment bond, that's another source that you can ultimately try to collect your outstanding payment from. And then ultimately the deadlines and the rules for getting collection on that bond will be within the bond language itself. So you will need to make sure you comply with the bond language. Now, lien and bond traps to avoid. I've probably touched on a couple of these already, but since they're traps, it's always important to reiterate them. With respect to the lien, when you file a lien in the state of New Jersey, almost every county I've ever dealt with, and I've dealt with many, require that there be a cover page that accompanies the lien. The cover page simply identifies the relevant parties that are at play in the lien, but if you don't include the cover page, the county will not record the lien. And if you're recording the lien via mail, obviously there could be lapses in time between the date you send the lien in and the date you find out it wasn't recorded. And given that time is of the essence and that 90-day window is black and white, you could miss a deadline over failing to provide the cover page. So be sure to include the cover page, and also be sure to, when you consider filing fees and of that nature, some counties require the filing fee be based on the amount of pages. So for example, your lien is 5 pages without the cover page, and the filing fee is $15 for the first page and $5 for each subsequent page. Well, if you're doing that calculation off of the lien without the cover page, you're going to include the wrong filing fee. So that could also be a reason why your lien gets rejected. So it's hyper technical, but you have to be sure to include the cover page and calculate the fee to the extent that the fee is based upon pages using the cover page. Don't wait to the 90th day. This ties into the first bullet point to some degree, but obviously if you're on the 85th day and you're trying to file a lien, and you're running the risk of those mistakes regarding cover pages and filing fees potentially jeopardizing your ability to file your lien. Because I've seen it happen. 91st day, lien filed. Court said lien invalid. It's black and white. And that lien, and there may or may not have been a valid excuse for why that date was missed, but If you have 90 days to file a lien, take full advantage of each of those 90 days. Don't include unimproved change orders in your accounting. So if there's a dispute over, additional work that was performed, and you, the contractor, believe that it's due, and the owner says, no, that wasn't extra work, that was base contract work or warranty work, or it was punch list work, well, don't include it in your lien, because if it's not a approved writing that approves the additional work, then it's invalid to include in the lien accounting, and it's invalid to include as part of your lien amount. It can ultimately result in your disqualification of the lien, and if your lien is disqualified after the 90-day window, you can't revive it. So again, hyper technical, but important to know. Use an accurate last date of work. This goes back to what we talked about before. If you use a date that is outside the 90-day window, your lien's invalid. If you use a date that you are performing punch list work or warranty work or work that was not really base contract work, or that was not used really completing the work, that can ultimately be rejected, and the lien can be declared invalid as well. So the idea is use the last date of work or materials delivered to perform actual work on the project, not corrective work or punch list work. Bond traps to avoid. Don't forget to send the pre-performance notice if you're a second or third tier claimant. I might have forgot to mention this, but if you are a second or third tier claimant on a job, within a certain amount of days, I'll go back to it really quick, prior to commencing work, that they must provide written notice to the bonded contractor by certified mail that the claimant is a beneficiary. So before performing work, if you're a second or third tier claimant, you need to notify the surety, you need to notify the owner that you are a potential claimant. So be sure to send that notice. Don't wait to send the notice of claim for the reasons I said before regarding the 90 days, because if you wait until until that 90-day window is about ready to expire, you might be out of luck in terms of filing your lawsuit. And like I said, use an accurate last date of work for the same reasons I mentioned with respect to the lien. The Prompt Payment Act. So this is another mechanism to leverage payment. It's a statute in New Jersey that requires owners to pay contractors within 30 days after the billing date, unless the owner provides a written statement explaining the reason for the withholding, and that needs to be sent within 20 days of receiving the request for payment. If no such explanation is given by the owner, then payment is deemed certified. Then payment is deemed certified. Then upon the contractor's receipt of payment, they have an obligation to pay their subcontractors within 10 days of receipt of payment from the owner. And that 10-day requirement goes down to each tier. So a sub receiving payment then needs to pay within 10 days down to its subs or to suppliers. One helpful mechanism is if payment is not being made as required, then a contractor or subcontractor can invoke its right to suspend performance without penalty if they provide 7 days written notice. So for example, if a subcontractor is not being paid by a contractor and they know the contractor's been paid by the owner, they can write to the contractor saying, you owe me. If you don't pay me within 7 days, I'm going to suspend my performance. And under the law, that suspension will not result in a termination. It will be a legally valid suspension. Obviously, if the project is needing to continue, that suspension could be enough to leverage a payment to the subcontractor. Another leveraging point the statute provides is it provides for interest, attorney's fees, and costs. So if payment is not being made within the timeframes required, then on a subsequent lawsuit, the contractor or subcontractor can seek to recover its interest, attorney's fees, and costs as a result of their as the upstream contractor or owner's non-payment within the time frame stipulated by the statute. All right, the right way to exchange a release for a check. So now you're finally getting paid. Well, what do you need to do to preserve your claim? So pay close attention to the scope of the release. Depending on where this dispute occurs, there might be other work, there might be other things that you still have disputes over, and you want to make sure that whatever you're being paid for, the language that's being identified, that's identifying the scope of what you're releasing, needs to be matching what you're being paid for. So for example, if you see language in the release that says you're releasing any and all claims, whether accrued or non-accrued or existing or non-existing, and you're only being paid for a disputed payment, 50% way through the project, well, you're not going to want to sign that release language. You're going to need to carve out and make this release specified to the specific requisition or invoice or whatever you're being paid for, and prevent it from releasing any other claims that are known or unknown, or future claims, or claims that may exist that are not being paid. For example, if there's multiple requisitions that are unpaid and you're only being paid for one of them, you're going to want to make sure that that release language carves out the other requisitions or invoices that remain unpaid. That ties into the second point here: preserve disputed claims. There's nothing wrong with writing in a lien release or a waiver anything that's not being released or waived. So if there remain other disputes, again, make sure that that document specifically says this is not resolving those other unresolved disputes. Same thing for a check. If hypothetically you have a dispute with someone that's worth $200,000 and they give you a $100,000 check and it says full and final payment on it, if you cash that check, well, you've now resolved your $200,000 dispute for $100,000. They can make what's called an accord and satisfaction argument to say that your cashing of that check has now released the balance of that claim. And if you ever receive such a check, refuse it, do not cash it, send it back, and frankly send a letter or any other written correspondence identifying that you are not agreeing to accept that partial payment as a full payment. So pay particular close attention to even the memo line or reline or any documentation that would suggest that payment is for full and final payment. Do not cash that check. All right, so that buzzed through the relevant issues here. So if anyone has any questions, I'm happy to answer them.
Thank you so much, Kyle. You really are incredible. I do appreciate all of those nuances and kind of going through it all with us. We do have a couple of questions that have come through. The first one, it says, in other states, some commercial properties have a lease provision recorded in the county stating that if you are contracted by the tenant, you are not able to lien the real property. Is that a similar thing in New Jersey? If that is in effect, can you file against the tenant's interest in the property? And then does that lease provision need to be recorded prior to the work performed?
So, I know that you can file a lien with respect to the leasehold interest. That is permissible. I don't know that to be honest, I'm not 100% sure if there's a contract provision in New Jersey that says that you can't file that lien, that would prevent you from being able to file a lien. But I think typically, I know generally you can file those liens, but now that I'm thinking about it, I think there needs to be some level in order for you to get an ownership interest type of, you could actually get a lien against the ownership interest if the work that you're performing for the tenant was also approved by the owner, and if there were other language that suggests that the owner was equally involved in that transaction. So the short answer, I believe you'd still be able to file the lien and potentially be able to file a lien against the ownership interest depending on other facts and circumstances and the owner's actual involvement or consent to that lien.
Okay, all right, perfect. Thank you so much for that. Another question that came through, it says, on public jobs, are second and third tiers required to serve a payment bond beneficiary pre-work notice to contractor to preserve the bond claim rights? Can you still file the claim without this notice being sent?
So you are required to send the notice. And with respect to a lien, if you don't send the notice, then it doesn't necessarily prejudice your rights, but it may prejudice your rights to the extent of the funds that are available, because you need to send the notice before you can file the lien. With respect to the bond rights of the claimant, I do believe that could be something that could be corrected, but you'd still have to send that notice before filing your bond.
Okay. All right, thank you. And then another question that has come through, it says, what is considered a residential property? Do multifamily housing, duplexes, apartments, condos fall into residential or commercial?
So it depends. If a multifamily property is a lease, so there's a lot of properties where they may have 50 condos and they're all owned by an entity that are leased to the residents. If that's a situation, that's a commercial property. But if each individual occupant owns their unit, then that would be a residential property. So the key is to focus on the residents that are living at the property and what is the resident status at that property. Are they tenants or are they themselves owners? If they're themselves owners, then it's a residential situation that would require the notice of unpaid balance. If it's a tenancy situation, then there would be a commercial property. Now, the one nuance there is if you could still have an owner-occupied situation where you're performing work for a tenant on a multifamily condo, but if the owner of the unit themselves, who's the landlord, is the owner of the property and not some leasing company, then that would still be an owner-occupied situation, not commercial.
Okay, and then I'm going to kind of piggyback off of that question. If, let's say, you're working on a condo or apartments where the individual units are owned by, not leased, so they're owned, but you're doing work for whether it's the owner of the apartment, complex or the association, whatever it happens to be, and you're doing work on the commercial space or on the common space, is that considered commercial property then?
So if you're working on common space inside of the, under your example, you said they're owner occupied, right? You said?
Yes.
Yeah, if it's in that situation, that could be, I haven't personally dealt with that situation. I think that would fall into a commercial, but I'd have to check you on that.
Okay. All right. Perfect. Thank you. I do think that that's all the questions that have come through so far. If anyone does have another question that didn't get answered, please reach out to us. We'll be sure to answer any questions as soon as we can for you. Can you go to the next slide for us, please?
Absolutely.
All right, here are some of SunRay's resources. Please check them out. We have really great information on our site. You can use that QR code and use our project information sheets. You can go and check out the different lien laws. Please note that every state has its own unique lien laws and document names and deadlines associated with those documents. So please check it out to make sure that you are protecting yourself and your interest in that project. And then also there's deadline calculators. There's a ton of information, so please check that out so you can better protect yourself moving forward on your projects. All right, and then the next slide, please. If you don't mind, here is a quick Google review. You can scan that QR code. We really do appreciate any feedback that you're able to provide to us. It helps us always better ourselves. And then the next slide, if you don't mind. All right, and with that, that is all we have for you guys today. Thank you so much to everyone who attended. We hope to see you guys at our next webinar. Kyle, I really can't thank you enough. You really are wonderful. So thank you again. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.